Let's start with conciliation, the last part of the Arbitration and Conciliation Act 1996. As we have discussed initially when we started with this particular act, that there is a difference between arbitration and conciliation. What is the difference? In arbitration, there is a judgment by an arbitrator out of the court, but that is known as award. But in conciliation, parties agree upon the settlement terms mutually through the mediation of the conciliator, and that settle agreement when signed by both the parties and the conciliator becomes enforceable just like an award. So when is the conciliation proceeding set to be commenced? See, if you will go through every word, it is written. Because we know the whole arbitration revolves around the written agreement. But arbitration agreement to be enforceable, it must be in writing. That's why it says that when the conciliation proceedings are to be commenced, first of all, a written invitation will be made by the party who wants to initiate the conciliation, and the invitation will be given to the other party. When the other party gives the written acceptance, it is said that conciliation proceedings are deemed to commence. But if the other party rejects the invitation, it has to be in writing. There shall be no conciliation proceedings. If no reply is received within 30 days of sending invitation or time specified in invitation, then party sending the invitation may elect to treat this as a rejection of the. See, this is important for MCQ. The party sending the invitation may elect to treat this as a rejection of the invitation to conciliate, and if he is so electing, it is necessary, mandatory for him to inform the other party in writing that he is treating the invitation of conciliation being rejected by the other party. How many number of conciliators shall be there? There shall be one conciliator, unless the parties agree that there shall be 2 or 3 conciliators. Now the MCQ is, how many conciliators shall be there? 1. If the parties agree, they can agree for the 2 or 3 conciliators, not more than that. This is where the difference lies from the arbitration, where the arbitrator will always be 1, 3, 5, 7. There is no limit on the number of arbitrators, but it shall always be in the odd number. And if the parties have not decided, then there shall be sole arbitrator. In this case also, this is there shall be 1 conciliator, but parties may agree only for 2 or 3, and it is not necessary to have the conciliator in odd number only, just like in case of it was in case of arbitration. So where there is more than 1 conciliator, they ought as a general rule to act jointly. Now, if there is a conciliation proceeding with 1 conciliator, both the parties may agree on the name of the sole conciliator. If 2 conciliators, each party may appoint 1 conciliator. 3 conciliators, each party may appoint 1 conciliator, and 3rd conciliator will be appointed by the parties through an agreement, and that will be called as a presiding conciliator. Now, the difference in the arbitration was both the arbitrator appointed by each party will appoint a 3rd arbitrator that who will act as a presiding arbitrator. But in this case, even the 3rd conciliator is also appointed by the parties, and the 3rd conciliator shall act as the presiding conciliator. Conciliator is not bound by the Code of Civil Procedure 1908 or the Indian Evidence Act 1872. At any stage of the conciliation proceedings, the conciliator may make a proposal for a settlement of the dispute, which need not be in writing and need not be accompanied by a statement of the reason that why he is giving a proposal for settlement of the dispute. The conciliation proceeding shall be terminated if the parties reach to a settled agreement and they sign the settled agreement. On the date of the agreement, the conciliation proceeding shall be terminated by a written declaration of the conciliator. After consultation with the parties, to the effect the conciliator declares in writing that further efforts at the conciliation are no longer justified. If a written declaration may be given by both the parties addressing to the conciliator that conciliation proceedings are terminated on the date of declaration. Even one party may give a written declaration to other party as well as conciliator to the effect that conciliation proceedings are terminated on the date of declaration. Resort to arbitral or judicial proceedings. One thing, if a particular subject matter is under a dispute and that is sought to be resolved through a conciliation proceedings, then the same subject matter cannot become the subject matter of any arbitration or judicial proceeding till the time conciliation proceedings are going on. That's why it is said that the parties shall not initiate during the conciliation proceeding any arbitral or judicial proceedings in respect of the dispute which is the subject matter of the conciliation proceedings, except, see, this exception is very important, that a party may initiate arbitral or judicial proceedings only when such proceedings are necessary for preserving his rights. That is, only in this case, parallel arbitral or judicial proceedings may be continued, initiated, otherwise not. Settlement agreement, if it appears to the conciliator that there exists element of settlement that could be accepted by both the parties, he shall formulate the terms of possible settlement and submit to the parties for observation. The parties will submit the observation, then the conciliator will reformulate the possible settlement terms in light of such observations. If the parties reach agreement on a settlement of the dispute, they may draw up and sign a written settlement agreement. If requested by the parties, the conciliator may draw up or assist the parties in drawing up the settlement agreement. When the parties sign the settlement agreement, it shall be final as well as binding on the parties and the persons claiming under them respectively. They cannot say that this is out of settlement, this is not binding on us. Once they signed it, it shall be final and binding. The conciliator shall authenticate the settlement agreement and furnish a copy thereof to each of the parties. What would be the status and effect of settlement agreement? It shall have the same status and effect as it is an arbitral award on agreed terms ahead the subject matter of the agreement being rendered by the arbitral tribunal under section 30. Had the award been made on the same subject matter under section 30 in the arbitration. Notwithstanding anything, section 75 we have read earlier also that the whatever being stated in any other law, it does not make any difference. The conciliator and the party shall keep confidential all the matters. It is their duty to keep them confident, whichever is related to the conciliation proceeding. Confidentiality shall extend also to the settlement agreement also, except only they will be disclosed for the purpose of implementation and enforcement of conciliation proceedings. Now, regarding the cost, conciliator, it's the conciliator who shall fix the cost of the conciliation and he will give a written notice to the parties. The cost shall be borne by the parties unless the settlement agreement provides for a different apportionment. Apart from that, such cost, if any other expenses incurred by a party, that shall be borne by the party itself. In case of deposits, just like in arbitration, we read that the conciliator may estimate the cost that may be incurred in conducting the conciliation proceedings. Then he may direct each party to deposit an equal amount. See, what would be the proportion if nothing is otherwise agreed? Equal amount as an advance for the cost which he expects will be incurred. During the course of the conciliation proceedings, the conciliator may direct supplementary deposits in an equal amount from each party. If the required deposits are not paid in full by both the parties within 30 days, the conciliator may suspend the proceeding or he may make a written declaration of termination of the proceedings to the parties effective on the date of the declaration. Now, what is the role of conciliator in other proceedings? Can he act as an arbitrator? Can he act as a representative or counsel of a party in any arbitral or judicial proceeding or as a witness? No. But it is again subject to the agreement between the parties. Unless otherwise agreed by the parties, the conciliator shall not act as an arbitrator or representative or counsel of a party in any arbitral or judicial proceeding in respect of a dispute that is the subject of the conciliation proceedings. The conciliator shall not be presented by the parties as a witness in any arbitral or judicial proceedings. Now, whatever happened during the conciliation proceedings, like the views expressed or the suggestions made by any party regarding the possible settlement of the dispute, or any party admitting something in the course of the conciliation proceedings, or there is a proposal made by the conciliator, or the fact that the other party was willing to accept the proposal for settlement made by the conciliator. Nothing whatever is related to the conciliation proceeding can be used as an evidence in any arbitral or judicial proceeding. I am saying any arbitral or judicial proceeding means in that arbitral or judicial proceeding, they may have the same subject matter as that of the conciliation proceedings, or they may relate to some different subject matter. They may relate to dispute which was not the subject matter of the conciliation proceeding. Even in that case, the proceedings of the conciliation or any few suggestions made or whatever happened in the conciliation cannot be used as an evidence for any arbitral or judicial proceedings. Now we will go to the fourth schedule, which is very important for the purpose of our basically exam also. I will say the name itself only, fourth schedule. Why? Because in 2015, this was the first time a fee was tried to be guided to the model fee in terms of fourth schedule. So I will suggest you to have a look at the fourth schedule, which is very important. Just have a look, because I should know about the basics of it. What is there in the fourth schedule, because before that until now in any profession there has been no model guidelines for what should be the fee for a particular professional to do something. But if you will go through it, the last schedule, just go through this fourth schedule. Just have a look at it. It is saying that the fee depend upon. Fourth schedule is dealing with the fee. First thing, the fee of the arbitrator according to the model guidelines depends upon the sum involved in the dispute, and minimum fee they are in the guidelines they are saying model fee should be 45,000. If you go through this particular thing, above 20 crore they are putting a cap. As and when the sum of the dispute is increasing, they are increasing the percentage of the fee. But if I go through the last column, it says that they are putting a cap that above 20 crore, whatever will be there, they will pay 0.5% of the claim amount, but it will be a ceiling of 30 lakh, right? And they are saying that if arbitral tribunal is a sole arbitrator, he shall be entitled to an additional amount of 25% of the fee payable as per the table set above. So this particular one, that is important for my exam. This particular 0.5% of the amount about 20 lakh with a ceiling of rupees 30 lakh, the name of fourth schedule, number of the schedule, fee depending upon the sum involved in the dispute, and the amendment was given in 2015. This was our 2015 amendment, right? This was what was important for the exam. Rest now we will go through the MCQs. This was what was required for our exam viewpoint for the whole Arbitration and Conciliation Act. Thanks for watching the video, and it's my request to attempt MCQs definitely, so that you can have a summarized version of what you have read in all these slides and all these videos, and have a look at video itself. Or if it is not the time, you can have only glance at the PPTs. Thank you.